SJC-13844, Town of Nahant versus Northeastern University.
Attorney Martin.
Good morning, Your Honors, and may it please the Court. Your Honors, residents of tiny Nahant have treasured the rare open space and oceanfront beauty afforded them by East Point for decades, so it's hardly surprising that a supermajority of Nahanters voted to use eminent domain to protect East Point against Northeastern's proposed development. That taking followed widespread discussion over East Point between 2018 and 2021, with residents organizing and raising conservation concerns not only within the town, but also with state officials and all the relevant town committees weighing in on the taking. The 2021 town meeting itself involved an extensive discussion of the stated purposes for the taking, with speakers both pro and con. Crucially, the town's subsequent order of intention limits the use of the easements to the purposes that were discussed at town meeting.
Were there more than, what were the reasons those who wanted the taking, what were some of the reasons that they gave?
Yeah, so the four stated reasons for the taking, Your Honor, were recreation, open space, conservation, and historical preservation.
Wasn't there also a suggestion of leverage against Northeastern University? We just don't want this 60,000 square foot, now 55,000 square foot building on that property. Weren't there statements to that effect?
So there was discussion of settlement. We do know from.
So I'm wondering, given that there were some proper purposes stated and some perhaps less than proper purposes, just for the sake of argument, why is it that Nahant is entitled to summary judgment?
So, Your Honor, settlement is not an improper purpose under this court's decision in Elks Order of Elks. You are allowed both to be moving forward with a proposal for an easement and also to negotiate.
Settlement is not what I said. I said, I think the record shows that there were statements made to the effect of using the threat of eminent domain as leverage to make Northeastern, come to heel.
Right, and that is not an improper purpose. If you look at the record concerning...
Why is that not an improper purpose?
Because if you look at the record concerning the discussions with Northeastern, they were all about moving the building off of the top of the Murphy Battery, which is where the current wildlife preserve is, moving it further away from the existing Lodge Park, which is a public park, which would be, in the minds of Nahanters, disturbed by having this new construction and building right next to it on the Northeastern parcel. And also in the discussions over settlement, Nahanters wanted to make sure that they would have access to the parcel for recreational purposes, which they had enjoyed up until 2018, and which Northeastern cut off when they began having their fight over the use of the parcel. It's really important to remember that these easements are not just to preserve the parcel against construction. They're also to ensure access of Nahanters to the parcel for hiking, birding, and all of the other activities that people enjoyed on that land.
So other than what it sounds like there's a material dispute of fact, can you point me to any case where there was a taking and there's an allegation supported by some evidence of bad faith where the town was entitled to summary judgment?
I can't speak to the precise procedural posture, Your Honor.
That's important because you're asking us not only to reverse summary judgment in favor of Northeastern, but to grant summary judgment in favor of Nahant. And it seems to me that there may be a material dispute as to the motives of the town.
And so we would disagree that there's a material dispute. And this is a really important point.
I understand that's your point, but it sounds like, and there's a whole decision going the other way. So it seems like a hard row to hoe for you to say that there's just no rational jury could come to the same conclusion as the lower court judge did here.
So this question, I think, would not go to a jury. It would be decided by a court. And when you look at this court,
no rational fact finder could find as this judge did below.
And we think this judge only reached the decision he did below because he ignored the most crucial evidence under this court's precedent in Pheasant Ridge. It's also important to look back to other precedents beyond Pheasant Ridge, like Dispatcher's Cafe, which is discussed in Pheasant Ridge when Pheasant Ridge is talking about how hard it is to prove bad faith on the part of the
Can you tell us what you think? Obviously, Pheasant Ridge came out the other way. Can you tell us, and you've made arguments that, for example, we traditionally defer and to, the essentially lawmakers in the form of town meeting, and all those arguments are well taken. But obviously Pheasant Ridge said, notwithstanding all of that usual deference, that we don't look and sort of try and analyze what 700 different members of a town were thinking in their heads and so on. Pheasant Ridge did that. So where do you think is the line? What would you describe as the standard for when we would put aside our usual deference to legislators, our reluctance to look at start deposing individual members of the town about what they were thinking when they cast a vote, and actually do that?
Right. So as Your Honor pointed out, Pheasant Ridge is very careful in describing the circumstances under which a vote by town meeting might be overturned by a court on the grounds of bad faith. Right? Pheasant Ridge says you should not easily attribute improper motives to town meeting. But in that case, the record required the inference, required it. There was no dispute as to any material fact in that case. The evidence showed beyond question. Right? So that's an extreme case, as the court made clear. Now let's take a step back and look at the precedent that Pheasant Ridge had in mind when it was coming up with its standard and announcing the bad faith test. Right? You have cases like this court's decision in Nevins versus Springfield, discussed in Pheasant Ridge, and I believe by the Attorney General's brief in this case. Everybody's assumed to be acting from improper motives. It's taken for granted that the conduct of public officers is in good faith unless it's shown to the contrary. Lynch versus Forbes, there's no constitutional right of a landowner to get into the facts underlying the determination of town meeting that land is suitable for a particular.
Well, but they did that in Pheasant Ridge. So when do we do that?
Because in Pheasant Ridge, there was literally no evidence going the other way. And so I think that's what's important here. If you look at the facts of this case as a counterexample, if you have a debate at town meeting, if you have the committees considering the question and weighing in on the question, everything in the ordinary course, as the Superior Court itself found in this case, then under other precedents like Dispatcher's Cafe, you really don't go further, right?
But wait a minute, though. In this case, I know that you're putting a lot about the discussion that happened during town meeting, but how much of that was I don't want to say polluted, but informed by, we have in the record that the selectmen wanted to, I think the quote is, stop this development. So why shouldn't those statements, for purposes of Pheasant Ridge, why shouldn't that be looked at as informing what then came with the discussion and the debate at town meeting, that they were essentially set up for this?
Your Honor, because there's nothing improper, and Pheasant Ridge makes this clear, nothing improper with stopping a project. What matters is the motive. If all that matters was you're stopping a project.
That's what I'm getting at. If their motive was, we want to leverage them to stop this, why isn't that a proper calculus of the motive of the voters of Nahant?
Because it's not stop full stop, it's stop because, and the because here is very important. And if you look at the record between 2018 and 2021, what you'll see is that the Board of Selectmen, residents of the town Community Preservation Commission, the Finance and Advisory Committee, were all weighing in and providing valid reasons for stopping the project, which are the very same reasons that were debated at town meeting and that are reflected in the order of intention. From start to finish, this was done exactly the way that Pheasant Ridge wants to see things done, which is have the relevant committees weigh in, have a debate at town meeting. And if it's all about proper purposes, not improper purposes, then even if it will have the effect of stopping your project, then it's fine.
I'm sorry. Then I have a related question to that, though. So you started off by talking about what Nahanters had always thought about this property and what they wanted to do with it and take advantage of it. So what's going to prevent going forward? What's going to be the rule going forward with this when it comes to any town or any community invoking some kind of scenic character to land and to block what would otherwise be a lawful development? What's going to be the for us at least, if we have to write this, what's going to be the doctrinal stopping point to that?
And so, Justice Georges, I think Pheasant Ridge gives you the tools to address this, because it says Pheasant Ridge spent most of its time talking about town meeting. So let's see what the actual debate was at town meeting. If the legislature in question is town meeting, what did that legislature have before it? What were they talking about? The problem in Pheasant Ridge was that there was no discussion of the public purposes there. Pheasant Ridge then takes a step back. It says, well, if there's not a discussion at town meeting, then what other evidence might support the notion that voters were acting in good faith? Let's see what the debate was leading up to town meeting within the town. Were the relevant town committees consulted? In Pheasant Ridge, they were not. Here they were, and there was extensive discussion of the stated purposes for the taking at the Board of Selectmen and the other relevant town committees. Even if you don't have that, go back a step further and ask if there was longstanding town interest in either the parcel or the neighborhood for the stated purposes of the taking. And if there is, that too may provide a basis to support a finding of good faith by the voters. I'm sorry, Justice Dwyer.
There's a question about motives, and then there's a question about purpose. And earlier you were using the word motives. Do we first have to, when does motive come into it? Because I thought that the question was, is it a public purpose? And when do we start looking at motives?
Right. I mean, if you look at Pheasant Ridge and earlier decisions, like, again, Dispatcher's Cafe, there's some flavor in those that if the ultimate purpose is a proper purpose, then that alone will get the project over the line, right? So this court said in Pheasant Ridge that even under the circumstances of that case, it would be a valid justification for the taking if the town truly intended to use the land for the purposes for which it was taken. Here we know that has to be the case because the order of intention and the easements that will be created under the order of intention go directly to what people were talking about at town meeting. So we passed that test. Now, I will say other parts of Pheasant Ridge suggest that maybe even if there's a valid purpose that will be the actual use to which the land is taken, you might still find it invalid. And so there you start looking at motive. I'm not sure the court should go down that road. It seems clear from Pheasant Ridge that the court was struggling with the question about dominant purpose versus sole purpose. And if here, I think we survive under either test. The Superior Court, I believe, was clearly incorrect in finding that what it thought was the dominant purpose of protecting the scenic value of the town was improper. And if it were to have considered town meeting in the actual terms of the orders of intention, it would have found additional purposes that are proper, like giving people access to the land that they've been denied since 2018 for recreational purposes, like historic preservation, like preserving the wildlife preserve.
You mentioned 2018. Leaving aside the issues about town meeting, I was looking at the municipal action. Can you point us to the record to any municipal action that was directed specifically to this parcel before 2018?
Yes, Your Honor. So, for example, if you look at the Natural Resource Zoning District creation, that specifically identifies by name the land owned by Northeastern, in addition to and separate from Lodge Park, right? So that's specifically about, and that's at volume 4, page 74. If you look at the 2000 and 2008 open space plans, they specifically list the Northeastern campus as land of conservation and recreation interest, in addition to and separate from Lodge Park. That's at volume 2, pages 125 and 269. The 2016 plan, which is limited, which is different from the 2008 and 2000 plans because it only talks about land owned by the town, talks about Canoe Beach, which is right next to where the CSI would go up. Sorry, Your Honor.
No, please, no.
Oh, okay, yeah, so you have all of that. I'll say too, under Pheasant Ridge is clear. It's not just the parcel itself, it's also the broader neighborhood, which matters for purposes of a good faith analysis. And here, the town's purchase of Lodge Park, its restoration of Lodge Park, which is right next to where the Coastal Sustainability Institute would go up on the Northeastern parcel, is crucial evidence because that is the kind of investment by a community in land that would be affected by development on a neighboring parcel, which would provide voters a good faith reason to take easements on a parcel for conservation and recreational purposes. In addition, there's a wealth of evidence in the record concerning the Northeastern parcel in terms of residents of Nahant, whether lawfully or not, we think lawfully, going onto the parcel to use it for the stated purposes of the 2021 taking. If you look at volume 3, pages 133, 189, and 375 into volume 4, pages 64, the summary judgment record had sworn testimony by, I believe, over a dozen Nahanters about their experience using the Northeastern parcel for recreational purposes and the use they saw others making of the parcel over the decades leading up to 2018. So if the question is, in 2021, could voters have had a good faith reason for taking this parcel for the reasons they did? All of that evidence supports that voters were acting in good faith. This was not a situation like Pheasant Ridge or some of the out-of-state cases on which Northeastern relies, in which nobody thought the parcel in those cases would have been useful for the reasons stated until they had some reason they wanted to block a development on the parcel, which was favored under state law, which is just not the case here.
Okay, thanks very much.
Thank you, Your Honor.
Attorney McLaughlin. So
Good morning, Your Honors.
I think the question here is going to be how, if viewing the evidence in the light most favorable to the town of Nahant, which the judge would have to do, can you explain how there's no genuine issue of material fact with regard to the proper purpose or whether they were actually wanting to take the property for conservation purposes?
Yes, Your Honor. I think a review of the record, and I understand that this is a de novo review, but Judge Karp, the lower court judge, wrote a 53-page decision. He had a 3,000-page record. He went over it line by line, and I think that he did a very detailed study of the record, and he found that there was no material fact. He found that
Is there anything
That's the
in there?
problem, right? He found. He's not supposed to be finding anything on summary judgment. He needs to take the record and view it in the light most favorable to the losing party and see if there's a material dispute of fact.
And he did that, and he found that there was none. And in fact, he made a point, I think, in his decision, and it's in the record, that at the summary judgment hearing, both I, on behalf of Northeastern, and both Attorney Masterman on behalf of the town of Nahant, both agreed that there was no issue of
But that
material
doesn't matter.
fact.
Parties often want to shortcut what could otherwise be an expensive trial by having summary judgment granted on their behalf.
I understand that, Your Honor.
It seems to me that, Attorney Martin has just delineated, and the briefs delineate, at least a view of the facts that would be a proper purpose for a taking.
Well, I don't think so, Your Honor. And I think
Why not?
you have to look at this. You have to look at Pheasant Ridge, and what Pheasant
Now,
Ridge...
Pheasant Ridge was an outlier. Taking property in order to prevent a development for conservation purposes has always been a proper taking.
I understand that, Your Honor, but it said, Pheasant Ridge also said, this is a unique case, but we're not saying it couldn't happen again. And what Pheasant Ridge said is you have to look at the
But
dominant purpose.
here we have a record of the town using the property for the reasons that they say they needed the taking. We have a record of a very active debate during the town meeting for conservation purposes, how they would like to do passive recreational activities on the land, how the 55,000 square foot building is going to interrupt that. At the least, there's a material dispute on that.
Well, my brother made those statements, but those
And they're
statements are not
supported by
backed
the
up.
record.
Well, I respectfully disagree, Your Honor. I think there was little to no...
So you're making my point. There's a
Well,
material dispute.
Your Honor, I guess what I'm saying is this. Under Pheasant Ridge, the court looks at the dominant purpose. And what we have here from 2018, when Northeastern first announced the project, right up until the town meeting, we have a drumbeat No talk about conservation. It's all talk about let's stop the project.
Well, isn't that the purpose of stopping the project? To continue to use this piece of property for conservation purposes?
It is not, Your Honor, and I'd like to point you to a specific part of the record, which I think is very damning on Nahant. Now, at Volume 6, Appendix 472, we have the Town of Nahant Board of Selectmen meeting minutes, Thursday, April 1st, 2021. So this is about 5 or 6 weeks before the town meeting vote. And if Your Honors would let me, although it seems as though you've obviously read the record and you're familiar with all the drumbeat of to stop the project, what is recorded here by the town in the last paragraph is this, quote, discussion about the need for the Conservation Commission to request the Board of Selectmen to take for conservation purposes, should that be the purpose of the taking, period. Does that need to take place before or after the town meeting vote? Now, that is damning evidence, Your Honor, because what it shows is 5 weeks before this taking, they still don't know what the purpose is. They're trying to think up a proper purpose. This whole conservation is a pretext. Reasonable inferences from the evidence proves.
How do you say it's a pretext when they actually put into place easements so that it will be conserved?
Well, the easement wasn't put in. What they did is they used ADA, and at the 11th hour, you can see them, and this is evidence of it. The town fathers are saying, now, we know we want to stop this project, and we know under
Are you
pheasant...
saying there aren't conditions put on the taking, that it must be used for conservation purposes?
No, there are, Your Honor.
They can turn around and build, a big property on it?
No, there are conditions, but what I'm saying is this. I think this is a very dangerous slope. I've been at this for over 40 years. I've tried probably over 100 eminent domain cases. I've never seen something like this. This is just a town abusing the power of eminent domain.
When you use words like pretext, doesn't that usually contradict summary judgment? It's an intention, a masked intention, a pretextual reason.
No, no, Your Honor. I use it as Pheasant Ridge did. And I think, as Justice Georges brought up, when you look at the language that one of the selectmen used immediately before the town meeting vote, and I believe Justice Georges said, doesn't this really kind of pollute the whole process? Doesn't it really? What he did is he lit the fuse. And I'd like to read to the court what he said. Now, this is, so we have a few weeks before, they don't know what the purpose is. The whole record's all about, let's stop Northeastern, let's stop Northeastern. Just like Pheasant Ridge stopped affordable housing, here they're stopping a Dover Amendment process. And if that isn't enough to light the fuse, Selectman Antrim says to the town meeting, quote, so if you are concerned about a tax increase, I think there's a very real risk of tax increase associated with a development accompanied with 228 people in town. It's a fact, if you have more people in town, there's a cost. We hired an independent firm, RKG, that did another assessment. And between those two analyses, that cost to the town over 40 years is between 14 and 27 million. All right, so the money has to come from somewhere. So after this development, the budget, I think, is around $70 million for a planned expansion. So if you're worried about your taxes, you won't vote against eminent domain. Now, that is a public figure. I think he was the chairman of the Board of Selectmen, making an outrageously prejudicial statement.
Do those statements bind the town in terms of our analysis?
No, they
under Pheasant Ridge.
No.
So given that, I'm wondering why. What do we do with it? They don't bind the town. there is a taking that's stated to be for conservation purposes and must then be used for conservation purposes. I'm wondering, you know, what is left for decision?
Well, it goes back, Your Honor, to the dominant purpose. What I'm saying, and another
But that statement you just read to us is not binding on the town.
It isn't, but what we have here, Your Honor, is in the summary judgment record, we have, as you realize, you have to submit a statement of undisputed facts. And I'd like to read, if I may, or at least draw the court's attention to those undisputed facts, because I think they're damning against Nahant. One of them, number 23, says, quote, "The town decided to pursue eminent domain when it felt that it had exhausted any opportunity to negotiate another site for Northeastern's proposed project."
So can I stop you there?
Sure.
So counsel for Nahant just told us that if we look at the Elks Lodge case, that's a legitimate purpose, settlement, leverage, all that is that not true?
That's not true.
There's no case that will say that it's a legitimate
No, you can't use the power of eminent domain to gain leverage. The power of eminent domain is supposed to be used for a legitimate public purpose.
Well,
It's not supposed to be used as a
so you can't use it as leverage for the legitimate public purpose of maintaining land for conservation purposes.
No, you can't. What you have to do,
What is
Your
the best case for that proposition?
I think, let me think about that for a
I
moment.
think that would be an important thought.
Well, I'll have Mr. Fowler, the brains of the operation,
I have a couple of questions,
think
if I
about that,
may.
and we'll give you a case, Your Honor. Yes.
I have a couple questions, if I may, about the relationship between the vote at town meeting and whatever may have been in the minds of the selectmen of the town. And so my questions, if you can step back from purely the realm of eminent domain, really go to sort of municipal law. Once the town, the citizens of the town take a vote, in this case, 2/3 to 1/3, roughly, for a particular thing, doesn't matter what it is, for a particular thing, are the selectmen not then bound to follow it?
Yes.
Okay, so that's what I thought too. So, and as long as that vote is facially valid,
Well, actually, let me back up. I think, Your Honor, I have had a case where the town has authorized a taking, and then the selectmen have not made the taking because they think it's against the town's interest. So what has to happen mechanically?
okay, but in this case,
Yeah.
let's assume that what the citizens voted for was particular language for the taking, which stated a permissible purpose under eminent domain law. Okay, so we're not in the realm of the exception that you just mentioned, I don't think. We're talking about a vote that is facially valid. No one's attacking the validity of that vote. And then we've got a situation, as far as I can tell, where I don't understand any basis by which the selectmen could disregard a valid vote at town meeting. What's bothering me here is that I don't read Pheasant Ridge at all to be an opening or an avenue for an inquiry into the mindset of each and every voter of the town. That would seem to me a completely unworkable system. Would you agree with that? It looks as though you agree with that.
I do agree with that.
So I assume that's not what you're asking us to do. I assume that's what no one's asking us to do. So we accept that vote as a facially valid vote. And then we accept that the selectmen must carry out that vote unless there's there's something unlawful about it or something. But here, what they voted on was a conservation easement that on its face states a legitimate public purpose. Why is that not the end of the story? Otherwise, it seems to me, I don't understand how we don't really run afoul of basic municipal governance principles.
Well, Your Honor, I think I disagree that that's the end of it. I think that and I think Pheasant Ridge does open the door. They talk about the federal case law opening the door to a town meeting, voting with the improper purpose. What happens here is, Your Honor, the motive, the purpose is clear. It is to stop the project, to stop the building. And that's an
Don't all conservation easements stop development?
Yes, but what you have to
So
do,
that can't be the way that we prove whether a purpose is invalid.
actually it can, Your Honor, because what happens is this. What Pheasant Ridge says is it says you go back and you look at the history, you look at the facts, and you look at what happened. And what we have here is there's nothing about conservation. When you look at the record, and I urge you to look at those undisputed facts, because as I said, I think they're completely
But what about the natural resource zoning district that expressly covered this land as of 1991?
I don't think it did.
You're saying it's not in the natural resource zoning district?
Yeah, Mr. Fowler just reminded me that it covers all of the land at the East Point, but it allows for educational development. So it allows for Dover Amendment.
What do we do with the problem here, really, or maybe the nice thing for the town here? This land has, as a matter of fact, been not dedicated, but used for conservation purposes.
It has not.
Well,
He says it, my brother says it has. It has not, Your Honor.
there's been buildings going up all over the land.
No, what we
There
have,
haven't been hikes.
no,
There's
it's
not an easement to get to Canoe Park.
No, what, Your Honor, and I'm glad you brought that up. And by the way, the case you asked for is really Pheasant Ridge. Pheasant Ridge
Okay.
covers the issue
Okay.
that you asked. This plan in the record, it's at volume 6, page 307. The black area, the shaded area is the only area of the Murphy bunker that they want to build on. It's just that small area. Now, as you read the record, and if we had the time, which obviously we don't, I could take you from 2018 up to the town meeting vote. There's nothing about conservation. In fact, the record shows, Your Honor, that they never used this land for conservation. It was overgrown with invasive species. And one of the open space plans, there were several open space plans, none of them looked at this property. They didn't mention it. And what they said, I think it was the 2000 open space plan. What they said there is, we have a Lodge Park, and that's all we need up there. There's this beautiful place for everybody to walk. That's all we need. We don't have to look at open space or conservation or anything up there. And Your Honor, I just think it's a very dangerous slope we're going down here. The power of eminent domain is awesome. And you can, if you
See,
create
you say this is a very dangerous slope that we're on. I would push back and suggest to you that in light of the deference that we normally owe to voters at town meetings, that the dangerous slope is perhaps the extension of Pheasant Ridge that you're asking us to make here.
Well, Your Honor, how about this dangerous slope? And I hear what you're saying, and that's an issue. I agree with you. But how about this? We don't want a mosque in our town. We don't want a drug rehabilitation center in our town. We don't want some other unsavory use in our town. And there's land that everybody agrees, no conservation qualities at all. So you know what? Let's under Pheasant Ridge or under Northeastern versus Nahant, let's just go there and dream up a reason. Oh, it's going to be.
But I think the key to your hypothetical there, and usually we ask the questions, but the key to your hypothetical there is that there in the blocking of the mosque, there was no conservation use of the land before, no recreational use of the land. And here, you're more familiar with the record than I am, but it seems to me the land right now, although owned by Northeastern, has historically been used since the 60s.
It has.
For recreational purposes, maybe legally, maybe not.
It has not, Your Honor.
And what we're going to do now is take what you've said, and we'll look at the record to see if that's true or not. And I thank you for your...
Thank you for your time, and sorry for asking the questions. I know you asked the questions. I didn't mean that in an insulting manner.
Thank you.